Dear colleagues, welcome. Our third speaker as a part of our launching events for Turkish Arbitration Academy is Professor Stavros Brekoulas. Professor Brekoulas is a professor in international arbitration. He is the director of the School of International Arbitration at Queen Mary University of London and an arbitrator at 3 Verulam Buildings, Grace Inn. Professor Brekoulas has extensive experience as arbitrator in both investment and commercial disputes under all major arbitration rules. He is being regularly listed in Who is Who Legal Thought Leader and Who is Who Legal Arbitration as being praised as a reigning thought leader in arbitration space and one of the great minds in the international arbitration world with a seemingly encyclopedic recall of jurisprudence. He serves in several public positions and commissions of trust, including being a member of the ICC Commission of Arbitration, the ICIA Court, the Lagos Court of Arbitration, Investment Expert Trade Advisory Group of the UK Department for International Trade, Steering Committee of the Uncial Academic Forum on ISDS. He is the editor-in-chief in Chartered Institute of Arbitrators International Journal of Arbitration, Mediation and Dispute Management, general editor of Journal of International Dispute Settlement, and the co-editor of Clover's International Arbitration Library series. His academic work includes the leading publications on third parties in international arbitration, arbitrability, ICA's Queen Mary Report on third-party funding, and numerous publications in leading legal journals and reviews. He will speak on non-signatories in international arbitration. Professor Brekoulas, the floor is yours.
Professor Yeşilırmak, it's a pleasure and indeed an honor to be here with you and present in the Academy. I think the work of the Academy is extremely significant, as I mentioned, and I think your work there and the work of the colleagues need to be commended. I'm especially delighted because with Professor Yeşilırmak, we go back several years together. He got his PhD from the same university here at Queen Mary, and his book on provisional measures is still the single most authoritative work after all these years. It is a pleasure to be asked by Professor Yeşilırmak, and as I said, it is an honor to speak with all of you. So thank you again for the kind invitation. What I will do is I will use some slides to make my presentation more accessible to all of you, and I will need to share my slides and my screen with you. So this is what I'm going to do right now. And I hope you can see my presentation. The topic of my presentation, as Professor Yeşilırmak said, is on non-signatories in international arbitration. Let me give you the context of it. And contemporary commercial transactions nowadays have become increasingly more complex. It used to be that we had 2 parties only participating in a single transaction, but now several parties participate for the delivery of the same project, for the execution of the same project. The typical example here is construction projects that involve the participation not only of the employer and the contractor, but several subcontractors on the engineering and the design side, suppliers that will provide the materials, banking and other financial institutions that will provide the funding and will provide also security for the project. The same is also the case with a number of other transactions, including maritime transactions, where you have the same contract be signed in a chain form by not only by the shipper and the owner, but also several consignees of the bill of lading. Joint venture agreements also require participation of several parties. Especially, it is a problem, or a reality rather, when you deal with states, which they usually employ state entities to conduct the transactions through the state entities. So you have a number of state entities participating in the transaction, and the state being at the very end of it, at the bank of it. And also the same question in relation to multinational groups of companies. So when you have several parties being implicated in a single transaction, and you have only one arbitration agreement that is binding upon two only of those two parties, the question is, what happens if a dispute arises and implicates other parties that are involved in the transaction but are not bound by the arbitration agreement? It is what I call a disconnect between commercial reality, which involves several parties for the execution of the project on the one hand, but on the other hand, you have only two parties being bound by an arbitration agreement. The question that arises is, when you come to the resolution of the dispute before a tribunal, can a party that has not signed an arbitration agreement, which I call a non-signatory party or a third party, can this party be joined to sign and be present before the tribunal? Or can this party participate, intervene in an arbitration between two parties that have signed the arbitration agreement? In litigation, this is not a problem because, as you all know, we have specific mechanisms, procedural mechanisms that allow participation of third parties in the pending dispute between two other parties. I'm sure you're all familiar with procedural mechanisms such as joinder, where one party can join a third party and ask the third party to participate, sometimes mandatorily. You can have the intervention by a third party directly in the dispute between two other parties in a national court. You can even have consolidation between two pending arbitrations or two pending litigations rather before a national court together. This is what you can do in the context of commercial litigation before national courts. The question that arises in arbitration is, can you do that the same? Can you pull in one third party, one party that has not signed the arbitration agreement before a tribunal? And the answer here is probably very, very difficult, because if a party has not signed an arbitration agreement, it is considered to be a third party, and unless consent is demonstrated by this third party to the arbitration process, it is very, very difficult for that third party to be joined in a pending arbitration. There are specific risks and dangers arising out of this problem, which is if you have several arbitration cases, several arbitration proceedings between two only parties, two groups of different parties, they may come up with different solutions, with conflicting determinations. You also waste procedural resources, you waste time, you waste money. So the fragmentation of dispute resolutions gives rise to potential conflicting disputes, but also wastes a lot of time and a lot of parties. So this is the problem that we have to deal with. How we deal with the participation of non-signatory parties in the arbitration process if you don't have these third parties to have signed the arbitration agreement. I'm sure many of you from your own practice recognize the problem, and you always have before a tribunal parties arguing that a non-signatory party must appear before the tribunal. And the problem that you have as an arbitrator is, how is this possible? How can you do that? Now, the straightforward answer to that, it is that you need to be certain, you need to be satisfied that the third party, the non-signatory party, has consented to arbitration. Now, of course, this is easier said than actually demonstrated. To demonstrate that the third party has signed or has agreed to arbitration agreement, although it has not signed, you need to be satisfied that there's something in the conduct of this third party that demonstrates that has implicitly consented to the arbitration agreement, notwithstanding the fact that he has not signed the arbitration agreement. So the question goes down, how can you prove consent to arbitration on the part of the third party? The question about third parties in arbitration is an old challenge. It's not something new. It has become more challenging because commercial transactions, as I mentioned originally, have become increasingly more complex. But the question as to how you bring in third parties in an arbitration, it's an old challenge for international arbitration. In the 80s, international arbitration theory and jurisprudence thought that they had an answer to that. They developed the theory of group of companies. I'm sure you're all familiar with it. And they thought that through this theory, they would be able to join non-signatories in arbitration, even if they haven't signed an arbitration agreement. It all started with the Dow Chemical Decision. It is an ICC award that was issued by a tribunal sitting in Paris. I've included a reference for you in case you find it useful, although I'm sure you must have heard of the decision. Very briefly, what happened there was that Dow Chemical, which is a multinational group of construction, produces a number of chemicals and it's involved in many construction projects, had some agreements with Isover and Saint-Gobain. And when a dispute arose, a number of subsidiaries and the parent company of the Dow Chemical Group brought a claim altogether as several co-claimants against the defendant, against the respondent in this arbitration. The problem was that not only the parties that have signed an arbitration agreement from the Dow Chemical Group brought a claim, but several of the parties of the subsidiaries and the parent company who had not signed the arbitration agreement were joined as a co-claimant. The respondent challenged the participation of non-signatory parties. They said, you have not signed the arbitration agreement. You do not have a right. You're not entitled to be present in the tribunal. Only those parties that have signed the arbitration agreement have a right to participate in the arbitration. The tribunal, that consisted of very important, at the time, arbitration figures, said that we will allow the non-signatory claimants to participate. We will allow on the basis of a group of companies theory that said three things: that all the claimants, including both the signatories and the non-signatories, were part of the same group, the Dow Chemical Group. They form part of a single commercial group. The second thing that they said, the tribunal said, is that the non-signatory companies had actually participated in the project, have taken part in the performance, conclusion, and termination of the distribution agreements. The distribution agreements contained an arbitration clause, and therefore, by contact, by performance of the contract that includes an arbitration clause, the non-signatory parties must be considered to have taken note of the arbitration clause and therefore have been consent to it. And the third thing that the tribunal said is that the factual circumstances surrounding the performance of the contract means that also the respondent knew of the participation of the non-signatory parties, and they didn't object to it. By not objecting to the participation of non-signatories in the performance of the contract, the tribunal assumed, inferred, that the respondent had also accepted the participation of non-signatories. So taking all these three considerations into account, the tribunal issued a decision in favor of the claimants, crucially in favor also for the claimants that had not signed the arbitration agreement. The decision, as you can imagine, gave rise to a huge debate in France. The respondent challenged the decision, but the Cour d'appel in France confirmed the decision of the tribunal and effectively endorsed the group of companies theories, the theory in international arbitration, and many tribunals following the Dow Chemical Decision accepted participation of non-signatory parties in arbitration. So a number of decisions in favor of non-signatories were issued in the wake of the Dow Chemical Decision. However, it is fair to say this. Most of the decisions that accepted the group of companies theories was tribunals sitting in France under the ICC rules. Outside France, tribunals were very reluctant to accept a non-signatory, a group of companies theory. Why? Because the applicable law, the national applicable law in other jurisdictions, does not recognize a group of companies theory. As you know, the most single important legal principle under commercial law is the theory of the legal separation between separate legal entities. Different legal entities must be taken separately, even if they belong to the same group. They cannot be taken together as being liable together. At the same time, they cannot be taken together also for the purposes of an arbitration agreement. So when tribunals sitting outside Paris decided to take a group of companies approach, they were bitterly disappointed by the fact that the national courts of this jurisdiction set the award aside. This is the case in the Peterson Farms decision, which I've also included the reference in your slides, where a tribunal sitting in London decided to take a more expansive approach and accepted jurisdiction also for non-signatories on theories that said that were very close to a group of companies theories. London court set the decision aside. London court said, you cannot do that. There's no such a thing as group of companies theories. So it is fair to say that nowadays the group of companies theory is pretty much defunct. It is not used by many parties in arbitration, and when it is used, tribunals tend to be very, very cautious against it. So what are the alternatives? If we cannot use group of companies theories to bring third party in pending arbitration proceedings, how can we do it? And there are a range of different theories that have been developed or are used by parties in arbitrations. And these theories are very well, I'm sure, familiar to you. Why? Because they are not international legal theories. They're legal theories that they're rooted in national laws, contract laws theories. You all have in your contract law, in your civil law, the theory of assignment, the theory of agency and representation, the theory of incorporation of an arbitration clause by reference, or the theory of third-party beneficiary. The difference between these theories and the group of companies theories is that these theories, as I mentioned, are theories that are very well embedded within national law contract legal principles. They're not alien to that, as a group of companies it was. And that is why these theories are getting accepted by many tribunals and many national courts. Let me spend some time discussing these theories, although, as I say, I'm sure you would be familiar from your own jurisdiction. The theory of assignment and transfer of a contract containing an arbitration clause. Let me give you this illustration. Let's say that we have company A and company B concluding a contract that includes an arbitration clause. Company B then transfers or assigns some of the rights of the contract to a third company, company C. The question that arises out of this assignment to a third company is whether, in case the third company, company C, which is the assignee, has a claim against A, does it need to bring a claim before a national court, or is C bound by the arbitration agreement that was included in the original contract? In other words, the transfer of the substantive claim comes together with an arbitration clause or is separate? Is A be bound by an arbitration clause with C? Can A bring a claim against C before an arbitral tribunal, or does it have to bring a claim before a national court? And the answer that is most likely in many jurisdictions, certainly in England, is that no, we don't need to specifically agree on the transfer of the arbitration agreement for company C to be bound by the arbitration clause. Even if the two parties, party B and C, agrees on the transfer of the substantive elements of the contract, the arbitration agreement comes together with it, is transferred automatically, as we say, the rule of automatic transfer, and is binding upon party C, even if the parties have failed to specifically agree for the assignment or the transfer of the arbitration agreement to the third party. You don't need to prove consent, specific consent for arbitration. If you have agreed on the transfer, the assignment of the substantive part, the arbitration agreement will be transferred automatically to the third party. This is reasonable to think so, because the arbitration agreement is an agreement that has been concluded between two parties to support the main contract, to support the substantive contract. Although we often talk about the principle of separability that insulates the arbitration agreement from the main contract, effectively, an arbitration agreement is there to support the main contract. And if the main contract is transferred, it's only reasonable to think that the arbitration agreement as a supportive clause will also transfer to it. So this is what English courts have said, and I've included again the reference to the case that said that especially if an arbitration agreement is drafted in wide terms, it will be automatically transferred to a third party. Another theory that is used by many parties to bind a third party is the theory of incorporation by reference. And the typical illustration here is this. Assuming that you have a construction contract between the employer and the contractor, and this construction contract includes an arbitration clause. The subcontract includes no arbitration clause, but the subcontract makes extensive references to many of the substantive provisions in the main contract. It provides, let's assume, by way of example, for the same extension, grounds for extension of time, or the same grounds for additional costs by reference to the main contract, or provides for the same periods of suspension or the same mechanism of suspension or the termination of contract as the main contract. So you have one subcontract making extensive references to and incorporate provisions that are to be found in the main contract. The question that comes up is this incorporation of the substantive part of the contract also suggest that the arbitration clause in the main contract will be transferred or be incorporated by reference in the subcontract? Do we need specific reference to the arbitration agreement so that this arbitration agreement is incorporated to the subcontract? And here, there's different views that have been taken in different jurisdictions. In England, in other modern law countries, national courts have held that, yes, you need to specifically refer to the arbitration clause in the main contract if you want this arbitration clause to be incorporated by reference. General references to substantive parts of the contract are not sufficient for the incorporation of the arbitration clause also to the subcontract. Other jurisdictions have taken different views. In the US and Switzerland, for example, general references to the substantive part of the contract have been considered to be sufficient also for the arbitration clause to be incorporated. Again, the idea here being that the arbitration clause is supporting the substantive parts of a contract, and if substantive parts of the contract are incorporated by reference, it is fair to assume that the arbitration clause is also incorporated by general references. I look forward to hearing more from you what happens in Turkey, because I know that different jurisdictions, as I said, take different approach to that. Another theory that has been developed for arbitration in relation to binding a third party, a non-signatory party, is the theory of third party beneficiary. As you will know, very often, some of the substantive contracts, the original parties to the substantive contracts, specify a substantive benefit for a third party. This is the case in insurance or construction contracts, where the original parties provide a substantive benefit for subcontractors or reinsurers. Now, if two parties have agreed that the third party will be able to enjoy the benefit as a third party beneficiary from a substantive contract, does it also mean that this third party beneficiary, if he wants to give effect to this benefit or bring a claim out of the main contract to enforce this benefit, is this third party beneficiary bound by an arbitration agreement? Even if the original parties have failed to say that the third party beneficiary will also be bound by the arbitration agreement. So that's the question here. Are they bound, or do you need specific benefit for that? And the answer to that is no. The third party beneficiary is again bound by the arbitration agreement, even if the original parties have not agreed that the benefit will be enjoyed, the benefit of the arbitration clause will be enjoyed by the third party beneficiary. And again, I want to hear what happens in Turkey in relation to third party beneficiaries. The fourth theory that I want to very briefly discuss with you is the theory of implied consent. It's more general than the others, but it's also something that is often used in tribunals, in my experience, for parties to claim jurisdiction over a non-signatory third party. The theory of implied consent basically is that rests upon the assumption that if a third party actively participates in a contract that includes an arbitration agreement, that this third party must be taken as having knowledge of the contract that is included in the substantive contract, and not only having knowledge of it, but has actually consented to it by contact, by implication. That reminds us the factual circumstances of the Dow Chemical Award. As you will know, one of the premise of the tribunal's decision there to extend its jurisdiction over the non-signatory parties was that, well, look, the non-signatory parties have actually participated in the performance of the contract. They must be bound by it, by the arbitration agreement that is included there. So the non-signatories, to be bound by implied consent, it is something that we understand, but again has given rise to dissimilar approaches in different jurisdictions. English courts in particular are very hesitant, very skeptical to accept theories of implied consent. As you will know, English courts give great emphasis on the written terms of the contract. Unless one party has clearly agreed, or at least a term that is within the four corners of the contract is expressly provided for one party, English courts tend to resist theories that a third party, non-signatory party, will be bound by something that never agreed. And this became evident in the Peterson Farms case that I mentioned, where the tribunal, as I said, relied to the implied theories of implied consent to expand its jurisdiction on signatories. But most recently, in the well-documented decision of the Supreme Court, the UK Supreme Court in the Dalla case. Very briefly, to summarize the facts of the case here. The Dalla company, which is a construction company, had agreed with the government of Pakistan to develop some houses and some facilities to host the pilgrims that will go to Mecca to pay their respects during the Ramadan. As you know, hundreds of thousands of people go there. That was the case, especially before the pandemic. But they wanted some housing facilities to accommodate those people. So the government of Pakistan agreed with Dalla to construct these houses facilities there. The negotiation of the contract was made directly between the government of Pakistan and the construction company. However, just before the agreement was signed, government of Pakistan said, I will set up a trust to sign the agreement. It will be a state entity trust, but it's not going to be the government of Pakistan that will sign the agreement. It's going to be a trust that will sign the agreement, and it's going to be the trust that will now oversee the development of the project. So the government of Pakistan distanced himself from the contract, set up a trust. The trust signed the main agreement, although the memorandum of understanding was signed by the government of Pakistan initially. So the government of Pakistan signed a memorandum of understanding, but the final contract was signed by the trust. And the members of the boards of the trust were appointed by the government of Pakistan. When a dispute arose, the government of Pakistan had at that time dissolved the trust. It was a state entity, and it was up to the state of the government of Pakistan to dissolve it. So the problem that Dalla had was, can they bring an arbitration? And if they can't bring an arbitration, against which party? There wasn't any trust at the time to bring a claim, but the government of Pakistan wasn't a signatory member of the arbitration agreement. The arbitration agreement that was included in the contract was not signed, as I mentioned, by the government of Pakistan. It was signed by the trust. What can the construction company do? Can they bring a claim before the government, against the government of Pakistan, before the courts of Pakistan? It's not a position that you want to find yourself in if you're a construction company. So what they did is that they commenced arbitration in Paris in accordance with the arbitration agreement. And they said, it is the government of Pakistan that is the real party here. Yes, they didn't sign the arbitration agreement. They set up a trust to sign the arbitration agreement, but it's the government of Pakistan that must appear before the tribunal, and it's the government of Pakistan against whom the award should be issued. The tribunal sitting in Paris agreed with the Dala construction company, said, you're right. Taking all the circumstances into account, we believe that the government of Pakistan, although it was a non-signatory party, it is the real party and must be bound by the arbitration agreement. The tribunal said that it is the government of Pakistan that was the party of the memorandum of understanding. Yes, they didn't sign the eventual contract, but the original memorandum of understanding was signed by the government of Pakistan. They communicated with us, the trust, using stationery featuring the government of Pakistan. The members of the trust were members that were appointed by the government of Pakistan. Some of them were ministers of the government of Pakistan. And the government agreed to act as a guarantor of for the trust. So the tribunal said all the circumstances demonstrates to us that the government had actually consented to arbitration, even though it was the trust that officially signed the contract. So the tribunal said, we conclude that an international arbitration agreement, the effects of an arbitration clause can extend to parties that did not actually sign the main contract, but were directly involved in negotiation and performance of that contract. So they issued an award against the government. The problem was that when the award came to London to be enforced, the Supreme Court disagreed with the decision of the tribunal to extend the jurisdiction over the government. They said, how can you do that? How can you extend the arbitration clause to a party that never signed the arbitration? They said it doesn't matter whether the government showed behavior that was a true party. What does matter here is that if a party takes the conscious decision not to sign a contract, this party means that it doesn't want to be bound by it. Lord Collins that gave the decision for the English Supreme Court said that on the face of the agreement, the signatories and the parties was Dala and the trust. The government of Pakistan did not feature anywhere in the contract. And therefore, the only party that can appear before a tribunal is the trust, not the government of Pakistan. The French Court of Appeal disagreed with the decision of the Supreme Court in England. They said, well, no, we're happy with the award. Under our mentality, the French tradition, you can extend an arbitration clause to a party that has not signed the arbitration agreement. Why? Because we believe that the government behaved as if the contract was their own contract. If the involvement of the government in the absence of the evidence that the trust took any actions, as well as the government behavior during the pre-contractual negotiations, and you remember that they signed the memorandum of understanding, confirmed the belief that the creation of the trust was purely formal and the government was in fact the true Pakistani party in the course of the economic transaction. And therefore, the French Court of Appeal gave effect to the award and disagreed in that form with the Supreme Court's decision. Again, I look forward to hearing how you think domestic Turkish courts would decide this case, and whether the theory of implied consent is something that would be acceptable courts of your jurisdiction, especially in relation to international arbitration agreements. So what do you do if you can't rely on a theory, or you have a theory? How do you bring a claim before an arbitral tribunal? You need, in addition to a theory, you need an institutional rule, a rule in an institutional set of rules that allows you to bring a party to join a non-signatory. And initially, not many rules provided for that. If you look back 15, 20 years ago, no institutional rule provided for a third party to be joined. Now, invariably, most of the arbitration rules allow for the participation of non-signatory parties. I don't want to spend too much time about that, but I think it's important also for you, if I may give a very brief overview of the rules in two main important institutions, the LCIA, which is the London Court of International Arbitration, and the International Chamber of Commerce. If you start from Article 22.1, little 9, the 2020 LCIA rules and the previous LCIA rules provide that the tribunal can join a third party if there's proof that the third party has consented expressly to such joining. How do you prove consent? You go back to the theories that I just mentioned, and you can say to the tribunal, yes, the third party has consent to it. Why? Because it has given its consent by implication, by contact. Another article that is important for you to keep in mind is Article 7 of the latest version of the LCIA rule, the ICC rules, that allows a party to join an additional party, which is non-signatory, but it must do that before the appointment of the tribunal. Why? Because you need to make sure that the third party that will be joined in the process has the same, expresses its views for the constitution of the tribunal. Otherwise, due process considerations may arise. That was the only provision, the only way under the ICC rules to allow for the joinder before the 2021 rules. The 2021 rules, however, have added paragraph 5 that allow the joinder of one party even after the tribunal has been constituted. I don't want to go into too much detail about this provision. I've included that in your slides, but you can read it at your leisure. But it is a new provision. It is a new additional paragraph that has been added only with the latest 2021 rules in the ICC, and allows, in exceptional circumstances, though, the option for a third party to be joined after the constitution of the tribunal. But how do you, as I said, you need to persuade the tribunal not only that it has the power to do so, but it's appropriate for a third party to be joined. And how do you do that? You do it by finding a theory to prove to the tribunal that this third party has consented to the arbitration. And here we go back to all the theories that I listed to you earlier. Theory of assignment, agency, incorporation by third party, or theory of implied consent. Only if you persuade the tribunal that the third party has consented to it by relying to one of those theories, an international tribunal sitting under the ICC rules or the LCI rules will accept to extend its jurisdiction over a third party that has non-signed the arbitration agreement. I'm conscious of the time. I've promised to Professor Yeşilırmak to speak no more than 45 minutes and leave some time for some questions. This is what I wanted to offer to you. I gave you an overview of how the problem of third parties, non-signatory parties evolved, how the tribunals tried to address the question of the third parties, non-signatories in the 80s with a group of companies theory, how now modern tribunals address this issue with new theories. We've looked into the theories. We've discussed about the different approaches taken by different jurisdictions, and we concluded by a very brief overview of the most important institutional rules on non-signatories and third parties. And I will stop here, thanking you for your attention and being very happy to discuss any question that you may have.
Thank you, Professor Brekulaakis. It was a very extensive and thought-provoking presentation, as always. I have a couple of questions, and I have my own question afterwards. Let me ask the questions posed to us. In the case of a transfer of contract, can the original debtor bring a claim against the assignor relying on the principle of autonomy of arbitration agreement despite the transfer?
Absolutely. You're absolutely right when you raise the question of autonomy or the separability of the arbitration agreement. Most tribunals, as I said, the national courts have actually accepted that, yes, even in those circumstances, you can bring a claim in arbitration because of the theory, the rule, the principle of automatic transfer of the arbitration agreement. So it's something that I think it would be accepted most likely by a number of tribunals.
Thank you. And the second question is, how the conduct of a third party should be interpreted? Despite not involving in negotiations or gaining benefit, should a third party asking parties to comply with the agreement be subject to extension?
That's a very good question. I think the answer to this question depends a lot on the factual circumstances. To what extent the participation of the third party was extensive, was meaningful, took important decisions for the performance of the contract, actively participated in the negotiation and the conclusion of the contracts, had a saying in the termination of the contract, was the brain behind the contract and the performance of the contract. These are all questions that are very heavily relying on the factual circumstances, and it's very difficult to give a general answer to that. But again, the other thing that I think it's important to keep a note, and I hope that this came through from the presentation, is that the applicable law is also important. If the applicable law is English law, it's very difficult to persuade an English court and therefore a tribunal sitting in London about extending its arbitration agreement to third party. If you're sitting in France, if you're sitting in Switzerland, you have better chances to do that, especially in under French law. But again, so I apologize, but it's very difficult to give an answer to this question unless you know the extent of the active participation of the third party in the conclusion and the performance of the contract.
Thank you very much. And my question is, what is next? There seems to be diversion of jurisprudence and decisions on the subject. What do we need? Do we need a rule, perhaps, for getting to uniform application, an amendment to model law?
Yeah, Professor Yeşilırmak, this is an excellent question, and I think that's something that I've been thinking about for a long time. We don't have a general theory which goes through at an international level to deal with non-signatories. So what we actually do is basically have different legal theories that are national legal theories under different national laws. And inevitably, we come to divergent approaches when we have to deal with non-signatories. So it can be patchy, it can be uncertain, but somehow, it works. So some people would say, okay, we need an international rule, an international theory, and I would be all for it. But it's very, very difficult to agree to an international approach, a standard international approach, because English courts, for example, would never agree to this kind of implied consent. And French courts would not agree to a theory that the only party that is bound by an agreement is that party that has put its signature on it. So national divergences I think, are premised on genuine differences in legal traditions. And these differences in legal traditions, Turkish law has its own legal tradition. How it is easy for the Turkish law to say, all right, I don't apply my legal theories, my national understandings, and I apply something that may be foreign to me. So it's a very important question, Professor Yusufirmak, but I'm not sure that we will ever come to the point where we have international standards to it. I think we still need to know what are the national approaches.
Thank you very much. One last question. Are the awards where tribunals are extending the jurisdiction over third parties, governments, in danger confronting with refusal of enforcement on the grounds of excessive use of jurisdiction?
Yeah, absolutely. That's another problem. That's exactly what the Dalla case came. They said exactly, you have a decision that was issued by a French court wasn't enforced in England. It wasn't a decision that was issued by a Mauritanian tribunal. They said, no, you cannot enforce this decision here. As you absolutely said, Professor Yusufirmak, it gives rise to questions, to problems about the enforceability. And which is a shame. It's a shame, but that's what it is. I think we also had a question by Mr. Budak. He wanted to have a question. I don't know, he raised his hand.
Of course. Professor Budak.
Professor Budak, apologize. Yes.
Okay. No. Just Ali would be good enough. Can you hear my voice?
Absolutely, we can hear you, Professor Budak.
Actually, it was not a question, but you referred the question a few times during your presentation. How would the Turkish courts decide on this matter? How would the Turkish approach be? I'm unfortunately unable to give precise information referring to the case law. Ali may be more informed about the matter, but to be honest, I'm not aware of any specific High Court or Court of Cassation decision on the matter. But let me share what I feel about it in general. When I consider the Turkish approach of the Court of Cassation to the matter. Here, I would say, as a general approach, still the traditional or conservative mindset prevails, which suggests or which states that the function of judiciary is a function of sovereign power of the state, and it's not only a duty but also a competence of the state to provide legal services. So any agreement disconnecting parties from the state authority to decide on the matters would be clearly stated as provided by law. So there are special form requirements in our laws about arbitration agreements, and there are strict form requirements, although there had been relaxing amendments in the last couple of years. So, that would be the argument. And anything other than a clear case where the text of the case suggests it could be a similar case to the Pakistani trust matter. And in any case which is according to the facts, which would suggest that it would be against good faith to suggest that the government or whatever the third party is not a party to the arbitration contract or arbitration agreement, would not be good enough to persuade Turkish courts, Turkish high judiciary to believe that or to uphold that a non-signatory would be bound with the agreement. One exception or one last word about assignment of contract.
Yes.
In case of assignment of contract, I would think that it would give the result that the assignee would be bound by the contract, because according to the general provisions of our Code of Obligations, our civil code, an assignee is bound by the contract, including any defense by the other party to the contract being available to the other party to the contract after the assignment, which includes also procedural defenses, including the arbitration defense, which is a preliminary defense in the Turkish legal system. So I think there would be two open gates in Turkey. One is the clear cases where the principle of good faith would function, and the other would be the assignment of contract, including the arbitration agreement. So that was my modest contribution.
No, this is an excellent contribution, Professor Budak, and I particularly value the point about the good faith, because there have been also some cases in Switzerland, which obviously you have the same concept of good faith, obligating a third party to participate in an arbitration on the basis of the principle of good faith, because you couldn't say something, you couldn't reasonably lead the other party to believe that you will be bound by the arbitration agreement. But now when the dispute arises, just because you haven't put your signature to it, now to say I'm not bound by it, it is against fundamental principles of good faith. And that's exactly what the Swiss Federal Tribunal has said. And I'm glad to hear that there's something that would be at least open to argue in front of the Turkish courts.
Thank you very much to you both. It seems that there's a room to improve for our law as well. And this is one of the subjects, I think, for Turkish legislature to amend our arbitration laws. There are a number of other issues like enforcement of emergency arbitrators' decision. And I think maybe UNCITRAL working group would focus on not theories, but specific circumstances under which arbitration agreement could be extended to third parties if such circumstances are satisfied. If you go through theories, it would seem impossible to agree on, but maybe focusing on factual issues and make it possible to extend arbitration agreement to third parties, which is the feature of arbitration, in my view.
No, I would be delighted if we were able to come to this common understanding. I think it will eliminate part of the uncertainty that now exists, surrounds the question of third party, and will make it easier for the businessmen to know where they stand. What happens in the case of a trust? Can you bring the government behind it before an arbitral tribunal or not? Because it's very, very unsatisfactory for a contractor or any other party acting in good faith to have signed an arbitration agreement with a trust only to find out that this trust doesn't exist when a dispute arises. What do? You bring a claim before the government, against the government of Pakistan, before the Pakistani courts. It's very difficult to persuade them. So you need some elements of good understanding and some certainty. So I really hope that Professor Yeşilırmak, your idea would be heard.
Thank you very much. Turkey is a party to UNCITRAL, and maybe they can propose to study the subject. Hopefully, if they take this view worthwhile to study.
Absolutely.
Professor Bırakılakis, it's a delightful, it's a delight to host you. Thank you very much.
It's my absolutely pleasure and an honor to be with you. And thank you again for this very kind invitation. I very much enjoyed the occasion, the contributions, and the comments. I hope to see you soon, this time in person, hopefully.
We hope to. Thank you very much.
You all have a nice afternoon and see you.